appeal in a matter of being a child.
Yes, Ms. Barons.
My lord, my lady, I appear on behalf of the appellant mother, and I will continue to refer simply to the mother and father as I understand the matter is going to be.
We are live streamed, yes.
Yes. And as you will be aware, these proceedings concern the party's child A, who is a little boy aged just 2. The case concerns an application by the father, who is the respondent to this appeal, and I appear on behalf of the mother together with my Leonard Jr., Miss Tate. I'm also accompanied by Miss Thomas and Miss Siegel, our pupils in chambers, and my Leonard friend, Mr. Gupta, KC, and Miss Best appear on behalf of the respondent father.
Yes.
Also in court are those instructing me. I understand that my client is in Coventry caring for the child as usual, but she is appearing on the link as well to follow the proceedings.
Thank
I
you.
believe that the father is doing the same thing from Romania. The proceedings are concerning the 1980 Hague Convention, and at the final hearing before the Leonard Judge, Mr. Justice Peel, in the High Court in early September, it was the father's application that A should be summarily returned to the jurisdiction of Romania under the terms of that convention. The appeal brought by the mother raises issues concerning the application of Articles 13A and 13B of the convention. The primary case under Article 13A being one of father's alleged acquiescence, and as my lords and my lady will be aware from the documentation, there is also a ground of appeal relating to the trial judge's decision under Article 13B. Before coming in more detail to the evidence and the issues that arise under those articles, I would observe at the outset the magnetic feature or the most essential point or backdrop to the case, which is, in my submission, that this was a case of the gravest sort of allegations of domestic abuse and of quite extraordinary factual circumstances in relation to the level of threat and fear that is in existence towards this mother and child as a result of the actions and the threats of this father. Of course, any judge dealing with cases of this nature must faithfully apply the law under Article 13B, and of course it is right that there must be consideration of protective measures, and one must look at those points in detail and whether a list of measures might be adequate. But in my respectful submission, this is a case where my Lord Justice Moylan's comments in Re B and also in Re S this year are of particular significance. I would refer in particular to paragraph 70, which is at page 547 of the authorities bundle, which I hope the court has received.
Can you just give us that page number again?
547.
Sorry, I've missed this as well. Could you give it again?
It's 547.
547, thank you.
And behind tab 24, I think.
Yes. So which paragraph did you say?
Yes, so the paragraph I wanted to really highlight at the outset is paragraph 70. The authorities make clear that the court is evaluating whether there is a grave risk based on the allegations relied on by the taking parent as a whole, not individually. There may, of course, be distinct strands which have to be analysed separately, but the court must not overlook the need to consider the cumulative effect of those allegations for the purpose of evaluating the nature and level of any grave risks that might potentially be established, as well as the protective measures available to address such risks. And in a similar vein, my Lord Justice Moylan, in the case of Re S just this year, said again the judge had to consider.
Sorry, where's
Where
that?
I'm so sorry. The reference for this one is 659 of the authorities bundle at paragraph 83. The judge had to consider the cumulative effect of the matters relied on by the mother and decide whether, if they were true, there would at least potentially be a grave risk that S would be exposed to physical or psychological harm or otherwise placed in an intolerable situation. And nowhere in his judgment did the judge address this question. So it is always necessary, as well as looking at the individual strands that are pleaded in a case, to stand back and survey the evidence as a whole, to see the entire likely picture on return from the child's perspective, perhaps using a colloquialism, to see the wood for the trees. And in my respectful submission, this was overall a case where the learned judge did fail to survey the totality of that evidence when looking at the likely situation for A. This was a case where, on the judge's own findings, the mother and her family are so frightened of and intimidated by this father and his family members in Romania that they scraped together and paid the sum of €13,000 just in the hope that it would buy them some peace from the ongoing threats to kill and aggression that they were experiencing from the father.
Is that the judge's finding?
Well, my lord, it's one of his conclusions, although I'm going to come in a moment to the difficulties with the ultimate decision that the father himself had not acquiesced, but he did.
But if we think about it, the initial motivation that the maternal grandfather appeared to have for engaging the elders in the negotiations with the father was to see whether there was prospect of reconciliation, wasn't there?
Well, my lord, that's not quite right, and that's one of the points I'm going to come to, actually, because it's not correct that the mother and the grandfather said that they wanted to achieve a reconciliation. The evidence was that it is customary, when there is involvement by Roma community elders in this way, that the first thing they do is ask whether the parents can actually stay together and reconcile. Right. And mother's answer to that question was no,
right,
because of the experiences that she'd had.
Well, we can look at that in the judge's judgment. And the yes. second objective was in order to see if a power of attorney could be achieved, wasn't it?
Well, that is something that the judge found was an important part, but one of my submissions is that that was an example of where the judge became deflected from the core evidence about this deal in the autumn of last year. There was evidence about the grandfather asking for a power of attorney, but as he reconfirmed in his re-examination, that was really tied to the agreement that he said came 2 or 3 days after the €13,000 was paid, where he offered to bring the child for some contact. It didn't undermine the core deal which creates acquiescence, which was €13,000 being price, as it were, for Akeem staying in England. And one of the issues in terms of the overarching findings or approach to the case that I was going to say is just that in relation to both Article 13A and Article 13B, I submit that the judge did fail to stand back and survey the totality of the evidence as a whole. In relation to the acquiescence part, there was perhaps some deflection or distraction by satellite issues or red herrings, in inverted commas, rather than standing back and looking at the totality of what it really meant if he found, as he did, that the €13,000 was in fact paid. But in relation to Article 13b, it is striking, in my submission, and perhaps an example of where this analysis on 13b went wrong, that when the judge came to analyse the issues under Article 13b, no mention was actually made, no weight was placed at all on the payment of the €13,000. And although my primary submission is that the judge was simply wrong not to find the father had acquiesced, of course, according to the judge's conclusions, it seems he was of the view that the money was paid effectively to buy peace from the threats. And if that was what he believed had happened, it's an extraordinary set of events, and surely that ought to have come much more heavily into the balance on the overall assessment of Article 13b and whether any list of measures, whether or not it's theoretically possible for Romania to put in place orders, etc., whether anything is adequate in the circumstances of this particular child. And of course, as the Convention and the explanatory report make clear, the exceptions to the general duty to return are welfare-based. Yes, of course, the primary policy of the Convention is to generally return children after a wrongful event, but sometimes that won't be the right thing to do. And the fact that Article 13b is of restrictive application doesn't mean that it should never be possible to meet. And intolerable may be a strong word, but surely the circumstances of this case are a situation that this particular child shouldn't be expected to tolerate. So, if I may deal then with the grounds of appeal in the order they appear.
So that's your overview, so to
Yes.
speak. Thank you.
So the first ground of appeal on which permission was granted goes to Article 13a, acquiescence. And as I say, the primary submission is that in the ultimate conclusion that the father did not in fact acquiesce or should not have been held to have acquiesced, the judge did fall into error in a way that was so plainly wrong and irrational in the context of the other evidence that it cannot stand. Just going back very briefly over the procedural history, because I'm sure that the court will be aware of the factual background from our skeleton arguments. But the case, of course, was issued in April of 2025, by which time A had been in this country with his mother since August of 2024. The mother and father are Romanian nationals, but the mother, who is still only very young, in her early 20s, moved to England with her family when she was 14. She then met the father on a holiday in Romania. She says that she went back and forth to Romania a couple of times, but really the relationship soon became one that was characterised by domestic abuse. And she didn't just suffer at the hands of the father, she also was mistreated and abused by the wider paternal family members who lived in the household with her, in the house in Romania that she shared with them all. The mother's family, meanwhile, remain living in this country, and the mother says that matters came to a head in August of 2024. She was found to be telling the truth about the fact that on the 12th of August, while her own parents were in Romania with her, she told them about the abuse she had been suffering. She also had a telephone call where she told the father that if he didn't come back to be a proper family with them, because at that time he was in England, she thinks, with his other partner, then she would be taking A back to live in England. And that is exactly what she did about a week later. The final hearing was originally listed at the beginning of September before Mr. Justice MacDonald, and at that time the mother had filed an answer referring to Articles 13A and Article 13B, but at the court door on the morning of the first trial, the mother gave further instructions that were relevant to the issues under Article 13A, and this was the first time that the events in relation to the €13,000 came to light. On that day before, Mr. Justice MacDonald, of course, very conscious that this was a Hague case, and there is obviously the need for efficient and quick decisions, there was some debate about what to do in these circumstances, and initially the proposal was that the mother would seek to file some further evidence overnight and still use day 2 to hold the trial. But following some discussion, it was really of the court's own motion that it was decided that wasn't practical and it ought to be adjourned, and 2 days were able to be found unusually quickly, really, given the current pressures on the family division, in just a few weeks' time. So it was in those circumstances that the mother was given leave to file a further statement from herself and also one from her father, because it was clear he'd been so involved in this issue to do with the payment of the money. But it was still a very tight timetable, so the parties left court sometime around lunch on the Tuesday, and the new evidence had to be filed, taking account of interpreters, etc., by the Friday. I'm setting that chronology out in a little detail only because there is some criticism by my learned friends for the father, and also within the judgment, of the fact that there wasn't evidence directly from the so-called Roma elders. For a number of reasons, I would submit that that's not actually relevant, and that was another point that the judge gave undue relevance to in his conclusions. But in any event, one can see how this event unfolded, the circumstances unfolded in early September, and that was the evidence that was permitted and the timescale that was given.
Why wouldn't it have been relevant to have evidence from the elders out of interest?
Because, my lord, the parties can and did give their own direct evidence of what happened in these discussions. And furthermore, these are, of course, summary proceedings. It was all
I get that. It was just what the elders could have said could have been relevant. It was the relevant point that I was more interested in.
Well, I suppose, yes, hypothetically speaking, it could have been, but it's not necessary. It wasn't necessary, and it wasn't a reason to be held against the mother, and certainly not, as I say, given the very abbreviated timetable and the way that it all.
Well, either of the parties could have sought to adduce evidence from the elders, and neither did. So
exactly.
Your point is that it wouldn't be fair to take it against one as opposed to the other, because it was an option open to both of them.
It was, and in the end, there was ample evidence about what happened, on which the judge was able to and should have made findings. So, as I say, it was not a key point. So, coming to the actual evidence that went to the acquiescence defence, of course, the key case or the leading authority on the meaning of Article 13A, acquiescence, remains the decision of the House of Lords in Re H, which is at tab 6 of the authorities bundle. I'm sure it is very well known to the court, but just before I go into the details of the evidence that the parties gave in this case, I would just draw attention to the fact that in addition to the well-known summary with the 4 bullet points, which comes at the end of that decision at page 90 of the law report and page 179 of the authorities bundle,
Sorry, did you want us to look at that, or were you taking it somewhere else?
Yes, I was just going to pause to draw attention to some of the earlier statements in
Right.
the decision because, of course, there is a very well-known summary, the four strands that are brought
Yes.
together at the end of Lord Brown Wilkinson's judgment, which is at page 179 of the authorities bundle. But that also needs to be read together with the other discussion, and I would draw attention in particular to page 175 of the authorities bundle. At between letters G and H, so towards the bottom of that page, he says that it is only where the wronged parent has said or done something which is clearly and unequivocally inconsistent with the summary return of the child that his actual subjective intentions are to be disregarded. And on page 176, between letters F and G, Lord Brown Wilkinson first of all says that the court should reject any construction of Article 13 which reflects purely English law rules as to the meaning of the word acquiescence, and would also deplore attempts to introduce special rules of law applicable in England alone. And then when saying what does Article 13 mean by acquiescence, in my view, Article 13 is looking to the subjective state of mind of the wronged parent. Has he in fact consented to the continued presence of the children in the jurisdiction to which they have been abducted? And then over the page, on page 177, next to letter D, it says, in the ordinary case, the court has to determine whether in all the circumstances of the case, the wronged parent has in fact gone along with the wrongful abduction. Acquiescence is a question of the actual subjective intention of the wronged parent. So that is dealing with the usual case where acquiescence has to be found based on the wronged parent's own state of mind or subjective intention.
I mean, in fact, it's expressed in two different ways, because in, as you say, in paragraph 1, on page 176, the has he in fact consented, and then in D, has he in fact gone along with. And I think the general view is it's gone along with.
Yes.
Is the right approach. Initially, anyway, subject to the additional point you're going to take us to.
Yes, but it's, as I say, it's that there is overall, looking at the totality of the evidence, that the court can find that they have gone along with or acted or communicated an intention which is inconsistent with a summary return. And then if one comes to the exceptional basis, it's important, it is said, this is still on page 177, to attach more weight to the express words or conduct of the wronged parent than to his subsequent evidence as to his state of mind. And judges should pay more attention to outward conduct than to possibly self-serving evidence of undisclosed intentions. That is still relating to, of course, finding the actual subjective intention. But then, if one looks at the other basis, which may be more relevant on the facts of the present case, because the grandfather and the mother both gave evidence that the father told them he had tricked them shortly after the money was paid, there is an exceptional basis, and it says at page 178, letter C, that it is a feature of all developed systems of law that there are circumstances in which one party A has so conducted himself as to mislead the other party B as to the true state of the facts, and in such a case, A is not allowed subsequently to assert the true facts as against B. Going on to the next paragraph, it says that there may be cases in which the wronged parent has so conducted himself as to lead the abducting parent to believe that the wronged parent is not going to insist on the summary return of the child. And then some examples are given, such as signing a formal agreement or taking an active part in proceedings. The next paragraph goes on to say, there are cases in which the wronged parent, knowing of his rights, has so conducted himself that he cannot be heard to go back on what he has done and seek to persuade the judge that all along he secretly intended to claim the summary return of the children. Then the final paragraph, where the words or actions of the wronged party show clearly and unequivocally that the wronged parent is not insisting on the summary return of the child, they must be wholly inconsistent with a request for the summary return of the child. And then in the final summary, it said that this is the exceptional basis of acquiescence, where the words or actions of the wronged parent clearly and unequivocally show and have led the other parent to believe that the wronged parent is not asserting or going to assert his right to the summary return of the child and are inconsistent with such return, justice requires that the wronged parent be held to have acquiesced. Now, in my submission in this particular case, the fact that the payment of the €13,000 was made on the mother's and the grandfather's evidence on the basis that A would be allowed to remain living in England with his mother plainly establishes acquiescence. And even if the learned judge had felt unable to divine what was in the father's mind at the moment that the communications were going on between the elders in the autumn of last year, it was plain as a pikestaff that this was a deal which amounted to acquiescence at the very least on the exceptional basis. There couldn't be a clearer case where justice requires this father to have been acquiescing, given the actions of the maternal family in the payment of this money. The money was also, of course, an example of express conduct, which ought to have weighed much more heavily in my submission in the ultimate conclusions of the judge, because although in Re H the example is given of express comments or contemporaneous evidence, which ought to have more weight placed upon them than later self-serving statements, perhaps in the more usual way, the best example of that is text messages these days. So there might be contemporaneous text messages between the parties, and they're likely to give a better idea of what everyone really intended at the time than witness statements carefully drafted many months later. But in this case, what we have is the payment of the money, which the judge did accept was paid. And given all the other evidence about what that €13,000 was supposed to mean on both parties' evidence, that surely should have been the magnetic feature and the weightiest evidence about what this father agreed to, or at least led everyone to think he was agreeing
to. Your ground of appeal is that the factual conclusion that there was no agreement amounting to acquiescence was plainly wrong.
Yes.
So it was, and so what you're submitting is the judge should have found that is this the sort of the core of it, that the father accepted the money or took the money. Is that part of it, or is that? Because at the moment the judge, as you've said, found that the money was paid
Yes.
by the maternal family, but he doesn't find, does he, that it was, or doesn't find necessarily that it was received.
Yes. So there's two big problems with the way that it's dealt with in the judgment. First of all, there is the question of what the €13,000 meant.
Or what paid for? Is that what
Sorry?
meant what it meant?
Or what
in the sense of what it was paid for.
What it was paid for, exactly.
Right.
What's the €13,000 was supposed to be the price of, as
Yes.
it were. And according to all the witnesses' evidence, so mother, grandfather, and the father, €13,000 was proposed during the discussions in September 2024 as the price for A to stay in England. And so, given that evidence, the judge's ultimate conclusion that the money was paid, but that there wasn't a deal communicated to the maternal family on that basis, can't actually stand. It's not logical. Then the second issue is that the
Are you going to take us to the element, the places in the judgment where
Yes.
Okay, in due course. Thank
yes,
you.
I will, my lord. Do you want me to just finish that point before? Because I just said there were two
yes,
things
no,
in response to
entirely
your
up
question.
to you.
So the second big thing in response to that question is that the judge came to an alternative factual scenario, which in my submission was not properly open to him on the evidence, because he accepted that the money was paid. The father, of course, had denied that he ever agreed to the deal and denied that the money had been paid. But he suggested, the judge that is, suggested that the money might just have been retained by the Roma elders. And that was not either party's evidence, and in my respectful submission, it was quite an extraordinary accusation to make against people who are, according to both parties, respected community elders acting in their capacity that is common within their culture and in a position of responsibility, chosen directly. There were two elders, one chosen by father, one chosen by mother's family. And to suggest that they basically stole this money from the maternal family and tricked everybody, it is really quite an extraordinary conclusion to reach when it
Was it
based on the evidence.
Where in the?
But
I remember the point in the judgment. Was it a conclusion, or was it a finding as such?
Well, this is one of the difficulties. Is that
Could you
it's
just
actually
point us
quite,
to where?
Yes, it's quite tricky to see whether that was the finding or whether it was the alternative scenario that the judge posited, which is that actually the father had tricked the family. So, my lord, if you wanted the reference, I'm grateful. It's page 103 electronic of the core bundle,
Paragraph
which is paragraph 46.
46.
So the difficulty is that at the end,
Well, the judge there says, I've set out my findings on these events. But I think his findings are at paragraph 26, aren't they?
some of them are, yes, but then this seems to be where the conclusions are reached, and they include this factual suggestion that the money might have not been passed on by the elders. So that's towards the end of paragraph 46.
I mean, I didn't read that as. I mean, I absolutely agree that he seems to be suggesting that it's possible that the elders have retained it temporarily or permanently, but all of that is then couched in the final sentence as the picture is confused, unclear, and uncertain. He's left totally unsure. There are no findings about that as such. Are there?
Well, there is. It is clear from the judgment that he accepts that the money was paid.
Yes, he does say that.
I
I
accept
accept, absolutely, yeah.
I think if one looks at
And
26, it might help, because he says there that this is where he deals with the money was indeed raised and paid. And then that's when he goes on to say it's plausible that the elders did not hand the money to the father and kept it. And then, as you say, puts forward an alternative conclusion that if the father did receive the money, then he deceived the mother's family.
Yes. And so those are the two key paragraphs where he deals with the money and whether it was paid. And the two options are the elders kept it, or it was passed on to the father, but he deceived the mother's family.
And your submission is that the first was not a, however the judge describes it, whether it's a finding, and it seems to be that he is referring to as a finding, there was no evidence to support the conclusion that it was even plausible that the elders might have just kept the money.
Yes. And then the alternative, the only other alternative within the judgment, is that the father deceived the mother's family, and that really goes more to my ground 2b, which is that even on the matters as found in this judgment, the father should have been held to have acquiesced, because if he was tricking the maternal family, what else could he have been tricking them about in the circumstances of this case?
No, I understand that. At the moment, you're dealing with what was the money paid for.
Yes.
So you've addressed the the finding that it was potential finding that it was kept by the elders, not open to the judge. But then, if you look at the end of paragraph 26, the judge goes on either version, the principal purposes for the payment from the point of view of the mother's family were, one, to persuade the father to stop his threatening behaviour, and two, to obtain a power of attorney. It was not to secure the child remaining in England.
Yes, and that combined with the other conclusions that we just looked at a moment ago in paragraph 46 is where I say that there is an unsupportable factual conclusion. So
you're attacking the conclusion that it was the principal purposes.
Exactly.
Okay.
Yes, that the final piece of the puzzle was that the money was paid on the basis that A could stay in England, and that was the bit that the judge did not find. But in my submission, given all the other evidence in the case, that was not a logical or rational conclusion to reach. But if I may just go back in time a little on this payment of €13,000 and the idea that one needs to look at the totality of the evidence or the course of conduct under Article 13A. This situation in Romania in autumn of 2024 did not begin with the discussions with the elders. In the witness statements of the mother and the maternal grandfather, they were both very clear that this first arose in a telephone call when the father said to the maternal grandfather that if the maternal family paid him a sum of money, he would let A stay in England. My lords and my lady, if you could please just look at the supplementary bundle, which is where the original evidence from the trial appears.
Which page is?
So first of all, the statement of the mother, second statement of the mother, which begins at page 170. And the really key paragraph is paragraph 9 at the bottom of page 172, where the mother says, in August-September 2024, father contacted my father. I believe he called him a few times. I don't know any further details except that he demanded payment and promising that if we could pay him, he would allow A to stay with me in England. It is customary in Romani gypsy culture for one parent to receive a payment if a child will be with the other full time. And I took this request as further confirmation that he was happy for A to live in England. The mother's statement then goes on over the page to explain that at the same time as this was being proposed, the father was continuing to make threats to kill towards the maternal grandfather and other members of the family. And so it's right that the grandfather did also travel to Romania under threat from the father. But the other reason why all of this happened was the father's own suggestion in that phone call that if a money payment was agreed, then A would stay in England. Similarly, in the grandfather's statement, he says the same thing. So that is the essential context to the grandfather then travelling to Romania in September. And in my submission, it is important to place the further evidence that was then given about the discussions in the autumn of last year within that key factual part of the background, because this deal has to be taken as a whole, and the entire premise of the family going there and talking to them in autumn 2024 was in circumstances where this child was already in England, there was a dispute about that, there were threats about that, but then also the father was saying if we can agree a customary payment, then he'll let A stay in England. That telephone call was something that the judge accepted did happen, and the judge accepted that it happened essentially as described by the maternal grandfather, although the judge didn't make precise findings about the words that were used, but he did say that the call was along the lines of what the grandfather had described. Neither the mother nor the grandfather were challenged on this on the basis that they were lying about this call, and indeed the judge in general terms accepted that it had happened. So that's the first really key point to put all of what came next in context. Then another part of the call that was accepted, and this is at page, going back to the core bundle, at paragraph 16. And it's page 95, sorry if you need the page reference again. The judge says that he accepted also that the father told the grandfather that if the money was paid, he would stop all proceedings in Romania. That's also very important in the context of acquiescence, because part of the analysis or the description in Re H that I went to a moment ago is about the conduct of the wronged parent being inconsistent with asserting their right to summary return. And so it's also highly relevant that as part of this proposal that began with a call from father in September 2024, he was saying the money would buy A, staying in England, and stopping the proceedings in Romania, because of course by that point he had actually already made, the father had already made a complaint in the Romanian court system. The next key point to which I wanted to draw the court's attention from the evidence below is that the father himself accepted in his own evidence in response to the mothers and grandfathers once this issue about the discussions with the elders had been raised, that €13,000 would be the price for A to stay in the UK, and that is at page 182 of the supplementary bundle. The top of the page is paragraph 14, just coming over from the page before. And he describes the meeting here himself. He says that he agrees a meeting was convened with the elders, that the elders travelled between the families to have discussion. Initially, they tried to discuss the prospect of reconciliation, but mother refused. Several proposals were thereafter discussed, and proposals put forward were A, I would be paid €13,000 for son to stay in UK. Now, of course, the father's evidence was that he never agreed to that and that no money was ever paid. But that evidence of the father is particularly relevant in circumstances where the judge's ultimate conclusions seem to have rested on the fact that in oral evidence, particularly the grandfather's oral evidence, other reasons were given by the grandfather for what he was trying to achieve in these discussions in September 2024. But those other issues, or the further evidence that the grandfather gave, did not detract from or supplant the key point, which was that everybody accepted, it was said during these discussions, that €13,000 bought A staying in England. And so that's one reason why I say that the judge's later conclusion that it was unclear what the purpose of the payment was, or that he was sure that the payment was not to secure A staying in England, doesn't make sense, given everybody's clear evidence about what the payment was for.
Well, just to pick up on that, because to be clear about your submission, the father was saying that whilst it might have been suggested that that was what it would be for, he never accepted that. Is that right?
Yes.
Yeah.
Yes.
So how does that translate into acquiescence?
Well, mother's case, of course, is that the father is simply lying when he says that he never signalled his agreement.
Yes.
But the problem with the judge's conclusion is that it seems to rest on the fact that the grandfather said some other things in oral evidence about what he was trying to achieve through this discussion with the elders.
Uh-huh.
And there was some confusion about this power of attorney point in particular. And also the grandfather referred to other things, for example, wanting peace between the families. And it seems that because of that, the judge didn't accept that the €13,000 was quite clearly on the basis that they were buying A staying in England. There wasn't really any confusion about that, but the judge seems to have become detracted on the other points that the grandfather mentioned in his oral evidence.
I don't want to oversimplify the judge's ultimate conclusions, but if I put it in this way, doesn't he really, in the end, say, whatever was discussed, everyone was at complete cross purposes about what the payment was for, and I'm left none the wiser? Isn't that a fair summary of his ultimate conclusions about this?
Yes, he does say that at one point, although then he also says he thinks that they were buying the ability to chat about things with some space and peace, and also that maybe the father had agreed to shared care. So the actual factual findings are quite difficult to discern from the judgment as a whole, I would respectfully submit. And that is one of the problems. But really, the finding that it was a muddle or that he couldn't understand what the money was for, I do say that that's an irrational or an illogical conclusion, because there was no question what €13,000 bought. The dispute between the parents was whether the father had actually agreed to that deal and whether the money was paid. The father wasn't saying these discussions, it wasn't clear what they wanted, or it wasn't clear that they were trying to come to a deal that meant A could stay in England. That really wasn't one of the potential scenarios for the court. So if, for example, one looks at the transcript of the evidence, oh yes, I'm so sorry, I should have checked that the transcript did reach the court, because we only got it on late on Friday afternoon. And
It did electronically, but I haven't got it electronically. Do you have a copy?
Yes, we do have hard copies actually, if that would assist. Sorry, I'm just being told that at the back as well are hard copies of the replacement skeleton arguments with the updated bundle references.
Okay, thank you.
Thank you very much.
Yes, so which page?
So if you go, for example, to page 59 of the transcript, this is the cross-examination of the grandfather.
Yes.
And the grandfather is asked by, sorry, actually it's just on the page before where this begins. Moylan and friend Miss Best asked, so no part of the discussions or the agreement was...
Sorry, wait a minute.
Oh, sorry.
Where are you, page?
So actually going back to the page before, the bottom of page 57.
Oh, 57. Yes. Got it, yes. Yes.
So she asks him, it's right, is it not, that no part of this was that if you paid money, that A could then remain living in England? And the interpreter says, sorry, there's perhaps not understanding the question there, but then she says again, so no part of the discussions or the agreement was that A would stay in England if you paid €13,000. And then he says, yes. And then you go to the page.
I see, yes.
And then Mr. Justice Peel says, yes, as in I agree. But then he gives the answer, yes, so we have been told by the elders that if we pay the 13,000, A then would be able to stay with the mother, with his mother. And then he's asked why that wasn't in his statement, but he says that he did say that. And it's then suggested to him that the father rejected that, but the grandfather says no, he did not reject. So in the judgment, the judge says that the grandfather hadn't actually told him that the purpose of the discussions was to ensure that A remained in England. That's at paragraph 21 of the judgment at core 96. But that's not actually correct, because the grandfather did confirm that, and he also did not resile from his earlier written evidence, nor was he found to have lied about anything. When the judge then goes to discuss what was said by the grandfather, it's right that there is some evidence about buying peace between families. And then there was also some discussion of the power of attorney, but none of that undermined the core point for acquiescence, which was the deal of 13,000 buying A, staying in England. The power of attorney seems to have become something which caused the judge difficulty or confused the picture. But in my submission, the evidence about the power of attorney actually supports what the maternal family was saying, because if they had already understood that they were allowed to keep A in England, that's why they were insisting, when they later suggested some contact with the father, that they ought to have a power of attorney so that they could then take the child back to England at the end of the visit. They wouldn't, or to put it another way, they wouldn't have been entitled to insist on a power of attorney to let them do that if they didn't think they were entitled to take A back to England again. So when the judge appears to conclude that the key aim of the grandfather in these discussions was for this power of attorney, that's a mistake or a misreading of the overall evidence, because the power of attorney only arises because of the deal that had already been struck, that A should stay in England. Another mistake which I would submit undermines the ultimate conclusion on acquiescence is the failure to take account of what the mother herself told the court about this agreement, because whilst it's correct that the grandfather was the one engaging in the discussions through the elders in Romania, obviously the mother was entitled to tell the court her own knowledge about what had gone on, and that should also have been weighed in the balance by the judge. So I've already taken you to the mother's written evidence, where she was very clear that the basis of going to Romania and the point of a payment was to secure a staying in England. But she also confirmed that in her own oral evidence when she was cross-examined. So she was actually first in the transcript. So if I can just take you back. So at the bottom of page 35 and over page on to 36. This exchange with Miss Best was in the context of it being suggested that the €13,000 was not to do with a staying in England, and so it's put to her, so it was not, I'm going to suggest about you agreeing that if you paid €13,000 to the father that, then she says yes, he agreed that, and then Miss Best says that A could remain in England, and she says again he agreed that. He said, I will allow you to stay with A, and I will never disrupt you if you give this amount of money. And of course, when this is starting, the gypsy judges will say, why don't you go back with him, and things like this. This is how everywhere starts. But if everyone says no, they will ask for money. F knew that we will have to pay, that he will get money from this gypsy thing. And then Mr. Justice Peel goes on to clarify this with her, and she again confirms that this meant that she would be able to stay in England with A, and also that he would stop the threatening. That's at line 14 on page 37 of the transcript. And so not only does the judge fail really to place any weight at all on what the mother herself had told the court about the circumstances of the deal, he also at one point misrepresents or incorrectly records what her own intentions were, because if you look at paragraph 20 on page 96, going back to the core bundle, the judge says that the mother had told him that her primary aim in the discussions was to try and effect a reconciliation with the father if possible, and if that was not possible, then to agree finances between them so as to stop what she describes as F's aggressive and threatening behaviour, in short, to buy peace. Well, that's not really what the evidence said at all, because first of all, mother did not say that she told the Roma elders she wanted to reconcile. The opposite was her position when approached by the elders, but what she did say is that it's customary for them always to ask. But secondly, she gave express evidence, both in her written statement and in her own oral evidence, that what they were trying to do, amongst other things, was ensure A would stay in England. The reference to trying to agree finances between them might be perhaps something that sprung from a line of questioning by Moylan, a friend, on behalf of the father, where at one point it seemed to be being suggested that what was going on in Romania last year was akin to a separation agreement or finances on divorce, as we would understand it through English eyes. But in my submission, if that's what the judge had in mind, then that was another significant and material error, because this was not an English financial case. This was something that was happening within a very specific cultural context, and it might be unusual to our eyes, but it's important to see it through the real personal and cultural context of these parties and not try to impose English ideas onto the circumstances. Because, as I say, when Moylan and friend questioned the mother, at times it was suggested to her that what they were trying to do was agree finances on their separation. But no one's case really was that that was what was going on, because the father himself accepted that this was a Roma elder discussion, and that part of it was a proposal for a payment of money to him on the basis the child would stay in England. And of course, that's not what would be the case if we were talking about separation finances here.
Sorry
Fine.
I'm so sorry to interrupt. Sorry, I've just got a little question. I just wanted to be sure that I'd understood what was going on. Did the mother directly deal with the elders, or was she hearing about what the elders had said, or what was being said to the elders via her father?
She heard about it from her father.
Yeah.
So
Okay.
the only person who spoke directly to the elders was
the
the
father.
grandfather.
I just wanted to make sure I'd
Yes.
not misunderstood. Thank
And
you.
it was described at times as a shuttle discussion. So
Yeah.
the father and the grandfather never met directly. Everything went through the elders. One
Yeah.
was chosen by the father and one by the grandfather. So there were two elders involved.
Yeah. Thank you.
So when the judge then comes to the conclusions and the final decision that the father hadn't acquiesced, in my submission, the parts of the evidence that he did in fact accept mean that that ultimate finding or conclusion was not consistent or rational. So, for example, at paragraph 23 on C96.
Sorry, first of all, I mean, you challenged you said that judge's analysis of the evidence was wrong in 20 and 21 and 22.
Yes.
And you've taken us to the written evidence and the oral evidence, because you're principally, because as my lady just said, it was the maternal grandfather who had the direct discussion.
Yes.
And so you specifically challenged Roman numeral 2 in 22. It was not specifically a term that A would continue living in England. You say that was
Yes.
A specific, and indeed you're saying on the evidence it was the primary
Yes.
element of the proposal and agreement.
Yes. And it's just not supportable to have found that in the light of what the written and oral evidence actually contained. And it's also, in any event, inconsistent with other aspects of the acceptance of the maternal family's case, because at paragraph 21, again still staying at C96, he does also accept that it was at least implicit within the grandfather's aims, so paragraph 21, that there was an expectation that A would continue to live with the mother in England. So in that regard, the judge does seem to be accepting that that was the whole underlying basis or core aim of the discussions, but in which case it doesn't make sense that he then goes on later at paragraph 46 to say that he was confused as to what the aim of it was, and he was certain that the payment wasn't on the basis they would stay in England. That just isn't, it's not rationally supportable on the evidence that was actually before the court. And the fact that, as I've already just gone through, the judge also has been mistaken in some of his summaries of the key evidence further undermines the overall conclusion about what happened. And it does perhaps demonstrate that he became deflected from the core point with the evidence about extraneous issues such as peace or the power of attorney. And as I've already submitted in the overarching comments at the beginning, one does need to stand back and look at this overall and see the wood for the trees under Article 13A, which is a part of a convention with children at its heart, and it needs to be viewed and constructed purposively, and it just doesn't make sense that the judge didn't find that in these circumstances the whole basis of this was acquiescence. It was on the basis they would stay in England. Then, on top of those specific examples of the evidence being either summarised or the conclusions not being supported when we look at what the parties actually said, overall, I also submit that the conclusion that there wasn't an agreement by the father for A to stay here, or that wasn't what the €13,000 was for, is inconsistent with the other evidence. So
your key point is that if you look at 46 towards the end,
yes,
where the judge says, not sure whether the money was passed on to F, but even if it was not, I'm confident, part of an agreement for A to live in England. You say that's inconsistent with the father's own evidence that what was being proposed, but what he didn't agree to, was that the money was for the child to stay in England.
exactly.
Yep.
Exactly. And when the judge says that he finds he wasn't sure the money was for that purpose, that's not supportable because of the other evidence. And when he says that the parties had different understandings or understandings which didn't align with each other, that's not a rational or consistent conclusion given the evidence that the money was actually paid and that the €13,000 was accepted by all parties as being proposed as buying A staying in England. it can't be that there was a lack of understanding. The options were either father was telling the truth that he never agreed to that, or the maternal family was telling the truth that it was agreed to, and that's why the money was paid. There's no confusion about what it all meant or what it was for. There are other elements that I would also submit show that the overall conclusion is inconsistent. So, for example, at one point, the judge suggests that the money was only paid in an effort to create some space for negotiation, or that the father had maybe agreed to some sort of shared care. That's at paragraph 23 on page 96. But that doesn't make sense if the money was actually paid over. And also, I would say as an aside, why on earth would the family pay that much money just to create some space for negotiation? That just doesn't make sense at all. I've already addressed, I think, the point about suggesting that the elders might have kept the money and why that wasn't a reasonable conclusion that was open to the judge. And again at paragraph 25, this is where the judge says that all the elders really did was lay the groundwork for some form of relative peace, to create some space within which the parties could decide on child arrangements. Well, obviously that was not what the maternal family thought they were getting, and they wouldn't have paid €30,000 for that. So, in the end, when the judge says that he is confident, and this is going back to paragraph 46, confident that the €13,000 was not part of an agreement for A to live in England, that conclusion just can't stand, given that he's accepted essentially all the other parts of the maternal family's case, and it was abundantly clear what that money was for. Finally, just on the flaws in relation to the assessment of the evidence on acquiescence, I would submit that the judge failed to take account overall of the father's demonstrable lack of credibility. And whilst, of course, I acknowledge the difficulty in overturning a judge's assessment of factual matters, and I also acknowledge the authorities relied on by my learned friends to the extent that a judge isn't required to incant mechanically or to mention every single line of evidence. In this particular case, it is a substantial and material omission from the judgment when the case hinged so crucially on the credibility of these parties. At the beginning of the judgment, all the judge really says about credibility in general terms is at paragraph 7. That's at page 94, the core bundle, where he says that he did not think M or F were particularly satisfactory witnesses, and the only explanation he gives for that comment is that neither of them could explain coherently why they hadn't, before the hearing, before Mr. Justice MacDonald, spoken of the discussion with the elders, and then he also said the grandfather seemed confused at times. But despite that introductory paragraph, there was no part of the mother's or grandfather's evidence that the judge actually went on to dismiss, or he certainly didn't find that they were lying about things. Although, of course, the ground of appeal that relates to consent was not permitted, the factual scenario or the call that went to the mother's case on consent, that there was this telephone call on the 12th of August of 2024 where she told the father of her intentions, was accepted to have taken place in the way described by the mother. So the reason the mother failed was just that the judge didn't find it was enough to establish the 13A exception. But mother was not disbelieved. So that was the first point where the mother's evidence was quite clearly preferred to the father's, because he had simply denied that that call took place. Then when it came to the evidence about what happened with the elders, the father had denied that he made this proposal to the grandfather in September 2024, or that he had made a proposal for a payment of money on the basis that A would stay in England. But the judge found that that did happen along the lines of what the grandfather had described. So that was another point where the father's evidence was disbelieved, but it doesn't seem to feature anywhere in the analysis. Then there was the evidence about the text messages that were sent by the father in the autumn of 2024. So there were two relevant sets of text messages. There were text messages between the grandfather and the father, in which the grandfather referred to having paid the father €13,000 out of fear, and the father's evidence about that was that it was a self-serving statement by the grandfather to bolster a position in, at that point, not yet ongoing proceedings. But the judge didn't accept that explanation, and so accepted the grandfather's and not the father's evidence about that. There was also some highly relevant evidence about text messages which had been sent by the father to the mother, also in the autumn of 2024 and in the aftermath of the deal, where the mother had referred to the father selling his family for money. Now, she clarified that she was referring there, of course, to the deal that had been struck shortly before with the elders. But the father didn't accept, in his oral evidence, that he had even sent those messages. He said for the first time, and it's at page 92 of the transcript if anybody needs to look at that the messages were not from him. But that was completely inconsistent with evidence he'd already given earlier in the proceedings, before the issue with the elders was raised, which accepted that he did send the text messages, although he tried to accuse the mother of provoking him into sending them. And the context for that was that that chain of messages also included a number of threats to kill and other aggressive comments from the father towards the mother and her family members. And so in his first attempt at explaining them, he was basically trying to blame the mother for provoking him into sending them.
Could you show us the reference to the father selling his family for money?
Yes. So in the first exhibit to the mother's first statement, it's at page supplemental bundle 112. This is a chain of messages from the father to the mother in autumn 2024, and
can I just ask how we know that it's autumn 2024?
well, that was the mother's evidence.
In writing or orally?
In writing and orally, I think, yes.
Sorry, I was looking at you say she sent a text, is this right? Saying that
Yes,
the father...
so the...
Yep, go on.
At page 112,
Yes.
the exchange begins, and this chain was also produced because it contains relevant threats from the father. And of course, in the mother's first written statement, she hadn't yet mentioned the deal with the elders in autumn of 2024. So that is what the text messages were produced for at the time, and that's what Father was responding to originally. But if you go to page, I think it's the third page of the messages. No, sorry, the fourth. So it's page 115. On the right-hand side is the messages from the mother, and it says, I think it's the last message on the right-hand side, "You sold your family for money," laughing emoji. So then in her second statement, which was the one she produced after the Mr Justice MacDonald hearing, where she explained the events in autumn of 2024, the mother also clarified that that is what she was referring to in that message. It was referring to this deal with the €13,000. But when the father was cross-examined about this, he first of all tried to suggest that they weren't actually from him, but that was inconsistent with something he'd put in an earlier witness statement, where he accepted they were from him, but he said mother had provoked him. He then tried to explain why he had not himself referred to the discussions with the elders earlier, by saying that he was trying to somehow protect the mother, or ensure that she wasn't put in a worse position in the Romanian proceedings. But he was obviously challenged about that, because his position in Romania is that A should be removed from the mother and placed with him. So that wasn't credible or coherent either. But when the judge overall looks at the credibility of the parties, or the totality of the evidence, there is really no acknowledgement of the fact that the father had been shown in several core respects to have lied, or to have given incredible or unsatisfactory answers, whereas all the key elements of the mother's and grandfather's evidence was factually accepted. It was even accepted that the grandfather had been told by the elders that the father agreed to the €13,000 for A to stay in England. The only little piece of the puzzle that was missing was an acceptance that father did actually communicate that. So before I move on to the further grounds of appeal, I just want to deal with a couple of matters raised by my learned friends. First of all, the skeleton argument on behalf of the father relies to some extent on the decision of Mrs. Justice Hale, as she then was in the case of P&P, and the proposition that ordinarily parents seeking to negotiate with each other in the face of a wrongful removal shouldn't be held to have acquiesced just because they've had some negotiations on the basis the child might stay where they are. But I would submit that that case really doesn't assist in the present circumstances, because it was a completely different scenario in the case of P&P, where both parties were represented by lawyers. There was an exchange of without prejudice and other correspondence, and it wasn't accepted that there was a concluded deal, and it's a completely different factual scenario from what is said to have occurred with the Romani elders in the autumn of last year. So it doesn't assist in this particular case. I think I've already dealt with the issue of not producing evidence directly from the elders, and the fact that given that all of the parties, including the mother, based on what she was told by her own father, were able to give evidence about the key points. It wasn't necessary to have the evidence directly from them, and also it shouldn't have affected whether the judge found the maternal narrative as opposed to the father's narrative about what occurred. The criticisms of not mentioning the circumstances before, in the mother's evidence and the grandfather's evidence, they both explained how frightened they are of the paternal family, and that, together with the mother's concern about not having a documentation of the bank transfer for the money, meant that she hadn't formally raised this issue before she came to court for the hearing before Mr. Justice MacDonald. And in my submission, those are perfectly understandable and consistent reasons for why this issue arose in the way it did on the mother's side. But on the father's side, there was no credible response or explanation for why, if he was just an innocent party and had never reached a relevant deal, he never mentioned any of these circumstances before it was raised specifically by the mother. And of course, by that point, the father had had three chances to file evidence in the proceedings, because there had been an original witness statement from his solicitor and 2 statements from him. So he'd had every opportunity to tell everyone about what had happened. Moving on then to deal with 2B just briefly.
Just before you do that,
Sorry,
can I
yes.
clarify one point of the history of the case? When the application was first brought in April 2025, your client indicated early on that she would be relying on the exception of acquiescence at that stage, and indeed Mr. Justice McKendrick's order of July 2025 refers to oral evidence being given on the issue of acquiescence even then. Am I right in understanding that the case on acquiescence at that point was based on the 12th of August 2024 conversation?
I think that must be right, my lord, yes.
I only ask because the case on acquiescence appears to have been flagged before the September 2024 negotiations, if for want of a better word, with the elders.
Yes.
So I really wanted to know what the earlier case had been referring to, and whether or not you pursued at all before Mr. Justice Peel any other strand of acquiescence.
Before Mr. Justice Peel or Mr. Justice?
No, before Mr. Justice
Hendrick.
Peel, you pinned your acquiescence case
Yes.
to the negotiations with the elders,
Yes.
didn't you? But it had already been flagged as an exception on which your client wished to rely before the evidence about the negotiations with the elders ever came to light.
Yes, it has. And from recollection, there was some discussion about that with Mr. Justice McKendrick at the hearing on the 3rd of July. But on that day, my client couldn't get to court. She was stuck on the motorway, and we couldn't get her there in time, so I wasn't actually able to meet with her. And we only had a very brief call on the phone outside before we had to go on before Mr. Justice McKendrick.
Right.
So at the time, I think Mr. Justice McKendrick also raised a query about what exactly the 13A covered, but I wasn't able to take further instructions on that date.
Right.
But the evidence, I think, was in at that point, so there was just the statement, the first statement from the lawyer at that point.
So was it referring to the August 2024 conversation?
I think that's right, but I'd have to go back and
All
check
right,
the
okay.
correspondence.
But it wasn't, in any event, by the time it came to Mr. Justice Peel, you were pinning your colours to the negotiations in September 2024 with the elders.
Yes, exactly, yes. So it became very clear that Article 13A consent was the call on the 12th of August.
Yeah.
And that was before Akeem had left the country.
Yeah.
Because he definitely left the country on the 20th of August.
Yes.
And then so the events with the €13,000 were subsequent, so they were
Yeah.
acquiescence, because that deal was agreed after he was here.
Yes. Thank you.
But the alternative submission under ground 2B is that actually even the findings that the judge did make, when standing back and looking at it as a whole under the exceptional test per re H, should still have led to a conclusion that the mother had succeeded because of the things that the judge accepted did happen. First of all, the call during which father proposed a sum of money on the basis A could stay in England, that has to be connected to what came after. It's part of the whole relevant course of conduct that creates acquiescence. There is the fact that it was an accepted part of the evidence that 13,000 was the price for A to stay in England, and that was communicated between everyone in the discussions. Paragraph 22 of the judgment, the judge accepted that the elders did tell the grandfather that A would be able to stay with the mother. And regarding what the father agreed to, or what the family were led to believe, the alternative factual scenario at paragraph 46 and 26 was that the father had tricked the maternal family. And so if that's right, then that must mean it was the exceptional basis under Article 13A, because if he wasn't leading the maternal family to believe A could stay in England, what was he tricking them about? So even if, which, as I say, in the primary ground it's not accepted, even if the judge's ultimate conclusion stands that the father himself didn't acquiesce in that discussion in the autumn of last year, the judge should still have gone on to find that at the very least the alternative scenario, or the exceptional basis, was satisfied. And justice required, in this case, that the father be held to have acquiesced. Ground 3, if I may move to that now, is an alternative version of acquiescence, which is that the court in Romania should be held to have acquiesced for the purposes of Article 13A. The basis of this submission was that the Romanian court, it was clear by the time of the adjourned hearing, had taken steps which, in my submission, are wholly inconsistent with a requirement now that A be summarily returned to Romania. It was accepted by all in the proceedings below that it is conceptually possible for a court to acquiesce, and the question really was whether or not the orders made in Romania did amount to such a situation. In the judgment, though, if we can look at paragraph 51 at page C core 104, this is where the judge deals with this submission. And the two cases which were provided as examples to the court were, first of all, the case of NM and SM, which was a decision of Mr. Justice Holman, and a case before Mr. Justice MacDonald called London Borough of Haringey, which was in 2024. Although that was in the context of the 1996 Hague Convention, he gave some more general guidance about the circumstances in which a court may acquiesce. The circumstances of the NM and SM case were that the applicant...
Do you want us to go to it, or...?
Yes, probably should do so at this stage, please. It's at tab 12, the authorities number. So at page 271 of the authorities bundle, that's where the essential facts of NM and SM are set out. And I accept that there was a difference in that case, in that the applicant parent in those Hague proceedings, who was in Ireland, was a same-sex parent who didn't have yet rights of custody for the purpose of the 1980 Hague Convention. However, an application had been issued in the Irish court before the abduction, and in accordance with the decision of the House of Lords, also in a re-H case, although this time in the year 2000, so not the acquiescence one, it was well established that it's possible for a court to hold rights of custody, and it was in reliance on those rights that the applicant brought a Hague Convention summary return application, which came before Mr. Justice Holman. In that case, Mr. Justice Holman concluded that either the case didn't come under the auspices of the Hague Convention at all, or that he should hold the Irish court to have acquiesced, because there had been ongoing welfare proceedings in the Irish court, and on more than one occasion, the child had been physically present in Ireland at the time of interim hearings, and no order requiring the child's interim return had been made. So, for example, at page 274 of the authorities bundle, Mr. Justice Holman refers to that factual situation, and even though it wasn't quite clear why no order had been made, Mr. Justice Holman decided that this meant that the court was effectively sanctioning the child's interim placement or interim residence in England pending the full-blown welfare proceedings in Ireland. So that was the reason why acquiescence was found in that particular case. And in the present case...
Just looking at that, I think in that case, paragraph 51, Mr. Justice Holman says, it seems to me the Irish court had a very clear and obvious opportunity, if it wished to do so, to assert and indeed vindicate its rights of custody, and it chose not to do so. So it was, he seemed to be saying in that case, on the facts of that case, and that follows on from, in fact, a passage in 49, the very court in which the only rights of custody in this case are vested, apart from those possessed by the mother, therefore had a very clear opportunity, if it thought fit, to make some order retaining this child. We don't know the reasons why it didn't do so, but we do know that it did not do so. So it looks as though the Irish court was making a very conscious, if I may put it that way, decision not to exercise jurisdiction, doesn't it?
Or not to exercise its power to order the child's interim return. Yes.
Yeah.
And that was the key point that persuaded Mr. Justice Holman to find the court had acquiesced. And in the present case, Mr. Justice Peel expressed concern that to rely just on that argument, so the fact that in this case there have been several hearings in the Romanian court and everybody knows where A is, but no interim order has been made requiring the child's return, Mr. Justice Peel felt that in this case it shouldn't be enough, partly because that might conflict with the decision of this court in the case of Re S. He refers to this at paragraph 52. And what he says is that it's very common for there to be ongoing welfare proceedings in the other court. And indeed, we have authority in the Court of Appeal here to say that ordinarily, where there's a Hague remedy abroad, a summary return order shouldn't be made because it might conflict with the purposes of the convention. And so simply that fact, the fact the Romanian court hasn't made such an order, shouldn't create acquiescence. Well, it all depends on the facts in my submission, and of course in NM and SM it was only that led Mr. Justice Holman to find acquiescence by the Irish court, because it was clear that they had had the opportunity and had not done so. But the difficulty with the judgment in this case is that the other part of the mother's argument on this point related to the interim direction which has been made for a welfare report, and that was the key reason. It was that combined with the lack of action to require a summary return in the interim, that it was submitted amounted to acquiescence by the court. But in the judgment, Mr. Justice Peel doesn't actually refer to this factor at all. And that is a material error, because that is the clearest evidence, really, that the Romanian court is not requiring this child's return in the interim pending the welfare proceedings. The Romanian case papers appear in the supplemental bundle. And
sorry, just so I understand. So the basis of this argument is A, the Romanian court was not specifically requiring A to return to Romania, has not ever made such an order, yes, and B, was making a direction, or gave a direction for a welfare type investigation in England.
exactly, and it's both of those things taken together, which I
together.
say very clearly establish the fact that the Romanian court is not insisting on this child's summary return, and of course the summary return being for the purpose of the welfare proceedings. So in the Romanian bundle,
were you going to refer to something in Hackney or not? Just while we've got this bundle. Haringey, which is thank you. Were you going to refer to a passage?
Haringey, no, well, the relevant passages are already quoted in my skeleton argument. But really, the Haringey case, if I may just come back to in a moment, in relation to what Mr. Justice Peel said about it, but I just wanted to make clear exactly what the mother's acquiescence by the court case was based upon, because it is missing from the judgment. As I say, Mr. Justice Peel only deals with the argument about the fact no order was made or no requirement for the return was made by the Romanian court.
And they also asked for a welfare report.
Yes, and that taken together with the lack of requirement for a return, which shows they are accepting that this child is going to remain in England in the interim. And you can see that this is the case because of the way that the request is framed. So these documents were only received on the eve of the adjourned trial. So it's right at the end of the supplemental bundle. But if you look, for example, at page 291 of the supplemental bundle, there is a letter from the Romanian authorities to the Foreign Process section of the Royal Courts of Justice, which says that they want to obtain a social investigation report at the residence of the mother in the UK. And then in my submission, it's clear that this is the equivalent of a full-blown welfare or Section 7 type report. If one looks at the things that it's supposed to cover, at SB, so Supplemental Bundle 316, it says it's going to cover the it's a social inquiry at her residence regarding the conditions for the upbringing and the education of the minor, the mother's income, the mother's living conditions, the persons with whom she resides, the minor's attendance at any childcare institutions or kindergarten, and any other aspects considered relevant. And the mother has received a letter from English CAFCAS to this end, for the purpose of preparing this report, because it has been requested through formal international procedures by the Romanian authorities. And so my learned friend has suggested that this might just be the equivalent of an initial welfare check, or just to check where the child is, but it's clearly not that. It's a welfare report. It's evidence about A, at his home in England. And so if that is what has been required, and at the same time the Romanian court is well aware, as it obviously is, that A is in England in the interim, and no order has been made at any of the hearings thus far requiring him to return in the interim, and they want this evidence of him at his home in England, well, obviously the Romanian court is accepting that A is staying where he is, at least for now. So, as in no summary return. And that is...
Could equally be deciding to wait until the English court has determined whether to make a summary return order under the 1980 Convention.
Well, my lord, there's no suggestion anywhere in the Romanian documents, though, that that is what the Romanian court has decided. There isn't, I don't think, even any mention at all of the Hague Convention case here.
Well, there
the
is,
welfare proceedings have been... sorry.
Isn't there... What's the order then? If we look at page 250, isn't that the decision on the father's application for... This is the initial initial application, going back into the autumn of 2024. And as I read it, the court in Bucharest declined jurisdiction to deal with what I think was effectively the father's 1980 Hague application in that country by saying you've come to the wrong court. And so, in fact, at page 251, in other words, says the order, says the judgment, the competence to decide on the return of the child lies with the administrative judicial authority of the state in whose territory the minor is alleged to have been taken, i.e. this country. So there's a very clear statement there that the Romanian court recognised that the country that was going to be deciding, or the state was going to be deciding whether the child returns is not Romania, but England and Wales. Then you look at the fact that the mother then challenges the jurisdiction of the Romanian court to make any welfare-based determination, and that's in the spring of 2025, and it rejects her application, doesn't it?
Yes, it rejects.
And says we have jurisdictions, and that's why it's different from and we propose to exercise it, which is distinguishable then from the Irish case, where they were effectively saying we're not proposing to make any orders.
Well, no, it's not quite the same, because the hearing in November, I think it was 2024, was simply the obvious result that the father had made a 1980 Hague application to the wrong place.
Yes.
So I don't accept that that gives any hint of what the Romanian court meant later on in August of this year when it made the welfare report order. And the father's application for substantive welfare proceedings came after that one was rejected. And yes, there was a dispute, an initial dispute about jurisdiction, and the Romanian court held that it retained jurisdiction under Article 7 of the 96 Hague Convention. But again, that was just them accepting substantive welfare jurisdiction, which they've then carried on with, because there have been a number of hearings since then in the Romanian court, although not very much seems to have happened. But what they then, once accepting that substantive welfare jurisdiction, have not done is say anything about the child being required to come back in the interim. But they also, I don't think, have said expressly they're not doing that because he's here or because it's for England to do so. But as I say, what becomes absolutely clear once you read the welfare report, or the welfare report request, is that the Romanian court is quite aware of where A is and wants an assessment of him in that place for the purpose of these proceedings. And so that is just completely inconsistent with then requiring his summary return in the interim, which is what the summary return is, of course, for, to go back for the substantive welfare proceedings. So that's why, in this case, I say that the Romanian court has acquiesced. And where it is suggested by Mr. Justice Peel that a different legal standard should apply because the proceedings are between two parents with rights of custody, or there isn't a local authority involved, I would respectfully submit that that's not correct. Whether or not the court has acquiesced must surely be decided on the same principles, regardless of how many holders of rights of custody there are. and that particular factual difference doesn't undermine or change what the Romanian court has accepted by its orders.
Yes. We're getting quite, I mean, I can't now remember because it's a while since I've looked at it, how other jurisdictions approach this idea that a court can have rights of custody. Because you will know the convention talks about rights of custody relating to somebody who has the care of the child. So in some respects, it might seem surprising that you have two parents who have rights of custody. You have a third entity who also have rights of custody because there are proceedings pending in front of that court. But so I think this is some way from the core of this case. And I look at the time, so I think we need to move on.
Well, my Lord, may I just pick up on that last point before I do, which is that it is well established by the case of Re H in 2000, which is...
I wasn't talking about this jurisdiction, I was talking about other jurisdictions.
Oh, I'm sorry, yes, well, I think it's right to say that there are other jurisdictions that have held rights of custody can be held by a court.
Anyway, as I said,
what I can't tell you is if there are other ones, examples of acquiescence by a court.
Yeah,
but it's my submission that if you can't really have one without the other, and it is well established that the courts can hold rights of custody, and therefore they must surely also be able to acquiesce.
Yeah.
And it is in overall alignment with the policy of the convention that the court here can hold the Romanian court to have done this, because of course the central purpose of the 1980 convention is to return the child to the other state for the substantive proceedings to take place there, and that's what the Romanian court is now saying they're not
But it'd be
expecting.
very easy for this to be resolved. Somebody could have made an application to the Romanian court saying, please, will you make an order providing for the child to remain in England pending the determination of the welfare proceedings in Romania, and that has not happened. So I think you really are stretching the argument some way. And as I say, looking at the time, I think we need to move on to your ground 4. Is it 4?
Yes. My Lords and my Lady, ground 4, of course, relates to Article 13b, and there are 3 aspects to this ground. First of all, it is submitted that the overall analysis of grave risk in this case failed properly to consider the potential level of harm to the child, and that the assessment of risk was both conflated with the question of protective measures and also allowed irrelevant or unfair considerations to creep in when the judge was looking at what the risks to this child were. Secondly, it's submitted that in light of the judge's own findings on the evidence in this case, there was no adequate analysis of what that meant for the level of risk to A upon return. And then thirdly, it is submitted that the question of protective measures was wrongly dealt with, because this was a case where there just were not any adequate measures to ameliorate the risks to this child. My Lords and my Lady, I am, of course, conscious of the time, and so I know that you will already have seen the evidence from the mother, but it's fair to say that this is a case where the mother makes really the gravest of allegations, and she has set out a history of really quite shocking and severe physical abuse, and also very sinister and concerning and serious forms of control and other emotional and psychological forms of harm. The background to the mother's relationship begins in the supplemental bundle at page 94, and her descriptions include, in summary, being physically hit, being abused verbally, both by the father and the wider family members when she was living in the house in Romania. Even before A was born, she was experiencing abuse from the father, and that was part of the reason why initially she went back to England.
This is paragraphs 15. Sorry, did you say page 94?
No, for page 93 onwards is where the allegations first begin.
Right.
Because, of course, she says that she first started experiencing abuse before the separation that took place when she went back to
the first
her
separation.
family in England, the first separation. On page 94, there are examples of her mistreatment by the paternal family members in the house in Romania. Restrictions on her movements, that's at paragraph 18. Not being able properly to speak to her own family, being spat at, being hit, not being protected from the paternal family by the father. And then when the mother was persuaded to go back to Romania again in 2023, so shortly after she'd given birth to A, he was actually born in England, it worsened. So there was an extremely serious incident in the autumn of 2023 when she says that the father was angered by her refusal to change A's birth certificate, because on the original birth certificate he hadn't been named. He got extremely angry, he beat her, he locked her in a cellar, he's threatened to kill her. There was such a serious assault that eventually the paternal family intervened, although they didn't immediately help her. She was locked in the basement. Going on to page 98, she says that the family locked her in her room at times overnight. And particularly upsetting and concerning as well, given the father's position in the Romanian proceedings, is that he does want to remove A from mother's care, is that she was prevented from properly caring for A. So he was taken from her during the day. At times she wasn't even allowed to breastfeed him. She didn't often have access to a phone because it was either broken or kept from her. And then, in addition to all of that, there is a wealth of evidence about the threats that the father has made, both towards the mother directly and towards her father and other family members. So at 112 of the supplemental bundle, I've already referred to those text messages sent by the father where he says that everyone's going to die, I piss on you, you will all die, you'll end up in prison, your mother dies, your father and brothers, I guarantee. Then there is the evidence that the grandfather complained of threats to kill to the English police. That's at supplemental 117 to 118 in August 2024. Coventry police recorded that as threats to kill, and the victim believes the threats to be genuine and fears for his safety. The maternal grandfather gave relevant evidence as well, in particular at page 158 of the supplemental bundle, about the threats towards himself and his wider family in Romania. And of course the evidence about the €13,000 deal is all in the context that, as well as proposing that deal, the father at the same time was making threats to kill. And it was under that fear that the grandfather travelled to Romania in the autumn of 2024. On that point, it might be relevant to note that in the grandfather's oral evidence, he actually mentioned that he had effectively been promised some sort of safe passage by the Roma elders when he agreed to go to Romania in the autumn of last year. That's the level of fear that he had. There have also been reports to the police in Romania by the grandfather's sisters, so the mother's aunts, and they are also extremely afraid of the family, and there have been allegations of threats to kill, of assaults in the street, and it said that there was one complaint made to the police in Romania, but other than knowledge that some sort of reference number has been given to them, there's no evidence that the Romanian police have approached the father or done anything else about this. In addition to the evidence about the level of abuse and the threats to kill and the obvious danger that that presents to A, it is relevant that there was evidence before the court that the father had gone to quite some lengths to get contact with A and also to find out where the mother and A were in circumstances where he knew she wanted to keep that from him. In the first statement in the proceedings, which was from Lucy Roberts, the father's solicitor, the father himself disclosed that he had been able to arrange video calls with A through a family member but without the mother's knowledge. That's at page 4. Of the... No, sorry, that must have been the original trial bundle. It's in a supplemental bundle. Oh no, this is the one that was missing. I'm so sorry. Yes. So this is the statement that should have been in the supplemental bundle and is not. So I wonder if at some convenient point I can pass a copy of it, but it is relevant to this point.
Have it?
Oh, it was in that little clip that was sent out, I'm told.
Yes, it was. Yes. So which paragraph?
Yes.
17.
So at paragraph 20 of that first statement from Miss Roberts, there's the admission that secret phone calls were going on. And then at paragraph 27, he said that he'd been informed they'd moved to a new address. And then that evidence also needs to be looked at together with the father's own third witness statement, which is in the supplemental bundle, which he was required to produce by the order of Mr. Justice McKendrick to explain how he had obtained mother's new address in England at the time that the tipstaff location order needed to be executed, because when the father originally approached the court, he said that he didn't know the mother's address and the usual orders were made. But in the end, the mother's address was supplied to the tipstaff by the father. And he explains in his third witness statement, which is at page 149 of the supplemental bundle, that effectively he did some detective work on Google Maps or Google Images when he saw the surroundings during a video call with A and took some screenshots of it.
Those are those exhibited.
Yes, they are exhibited, yes. And so the obvious point is that if the father has been able to do this and to circumvent the mother's own wishes to this extent when she is physically in England, it's easy to see how vulnerable and exposed the mother and by extension A would be if they now have to return to Romania, to a place where the father is, on the mother's case, of great influence, and she justifiably is extremely frightened of him. It also completely undermines any reliance that the judge placed on the efficacy of protective measures, because in my submission this was a case where the legal position in the abstract sense, the fact that measures could be technically enforceable in Romania, is not an adequate answer, given the very extreme risk posed by this father and the evidence that's already available about his willingness to circumvent mother's self-protection and also his willingness to break the law, frankly.
Can I just, while you're dealing with protective measures, the judge's order required a number of measures to be declared enforceable
Yes.
by the Romanian court. Has that happened?
Not as far as we're aware, no.
Right.
We don't even know that any application has yet been made. If it has, we haven't received the paperwork. So that is the factual context in which 13b came before the court. And the judge begins the analysis at paragraph 64, going back to the forebundle, page 108. By saying that it's appropriate to take the mother's factual case at its highest. He refers to there being at least some independent support for it, the aggressive and abusive text messages, and says that he cannot confidently discount the complaints and assertions made by the mother, or conclude they are unfounded or exaggerated. So that is the starting point, that all the things I've just summarised and referred to in the papers, we have to proceed on the basis that they are true. However, in my submission, what then happens in the judgment is that he falls into error because he goes on to start conflating the assessment of the situation on the basis that all those things are true with things that could ameliorate them or possibly discount the level of risk. It's not quite clear. So to show you what I mean, if one goes to paragraph 66, having accepted that these are very grave allegations and that they potentially meet Article 13b, and he also accepted my submission based on Baroness Hale's statement in Rule E, that even a low risk of serious harm can fall within Article 13b as much as a grave risk of lesser harm. And of course the key point there was the evidence about all of the threats to kill. Clearly a threat or a risk that the mother of this young vulnerable child is going to be murdered is the gravest possible risk, and so even a low risk of that must surely meet Article 13b. But having said all of that, the judge then goes on to say that he must consider the impact of this on the mother and the effect upon her and by extension A. And then in this paragraph he goes on to effectively, it seems, discount the level of risk on the basis that the mother, first of all, had previously been willing to reconcile with the father, and secondly, that she had previously been willing to facilitate some contact. In my submission, it's completely wrong to hold it against a victim of serious abuse, but at some time they may have wanted to continue the relationship with their abuser. It is very well established that victims of abuse do not always act rationally or sensibly or wisely or in their own protective best interests, and they often fail to separate at the first opportunity or have multiple separations and returns. So that certainly doesn't affect in any way the level of risk from this father if it is being accepted that what the mother has said in her statements and any other evidence is true. In relation to the reference to contact, again, whether or not at some stage the mother has indicated willingness to agree contact, that's not something which affects the level of risk from the father if what mother says in her statements are true. I would also suggest that it's not...
I think it was, rather than the willingness to agree contact, I think the judge was probably focusing on happy to travel to Romania to facilitate contact. Was that a matter that he was entitled to take into account?
Yes, well, I'm not I'm not sure that it's quite accurate to say that this mother was happy to travel to Romania to facilitate contact. There is evidence where she suggested she would be willing in principle to visiting Romania, and of course there's the evidence that her own father made some suggestions about a visit to Romania in the aftermath of the deal last year. But of course these are summary Hague proceedings. There is no detailed evidence before the court about exactly what terms contact would happen under, whether other protections would need to be in place, whether it could happen on an interim basis, etc. Those would all be the province of welfare proceedings. And in any event, this is a young, vulnerable victim of serious abuse, and she may not always have acted wisely or in A's own interests when it comes to offering contact. There are any number of reasons why a victim in this situation might try to appease the abuser, but it doesn't undermine or detract from the force of the very, very serious facts as set out by the mother in her evidence. So it wasn't fair or principled to refer to these as effectively reasons why the return might not be quite so bad. Then the judge at paragraph 67...
Just before we get onto that, can we agree that he's got his initials wrong? I think at the bottom of paragraph 66, it follows that a return for, and that should be A, I think, shouldn't it? Would be
yes,
manageable.
I think that's just a typo.
Yes, and just whilst we're on the same subject, 68.
1.
Yeah, 1 should be his return with M.
Yes.
Yep, thank you. Sorry, you're going to go to 67.
Yes, and so sorry. At the end of paragraph 66 and also 67, there's another error, which is where the judge appears to consider that the relevant question is, will this return destabilise the mother to the extent that A would be at grave risk of harm? And he refers to her emotional state and the state of her mental health and the effect upon her of a return and whether that would jeopardise the care of A. Now, it's right that there is a paragraph in the mother's witness statement where she referred to the stress that she's under, losing weight, going to her GP, and the understandable worries and how that's affected her. But that was not really the key issue in this particular case under Article 13b. It might be part of the cumulative picture overall, but this wasn't, if I may put it in inverted commas, a mental health case. The mother's primary 13b case was not that she was going to be so mentally unwell, that was what really created the grave risk. The risk in this case is very obvious. It's the lengthy evidence and very detailed evidence about domestic abuse and controlling behaviour and threats that I've already described. And that was at the heart of the risks to the mother and by extension A. The next paragraph goes on to mention the possibility that there will be a separate home and therefore A wouldn't be further exposed to domestic abuse between the parents. I'll come on in a moment separately under C to look at the protective measures and their inadequacy, but the point about this part is that, again, it seems that this is being used as a way to reduce or minimise the overall risk, but it's not an answer to the very serious allegations which this mother has made. The most obvious example being the threats to kill. Just having a separate house, that doesn't deal with that risk. Father only needs to breach an order or do that once, putting it bluntly. Paragraph 69 in my respectful submission is an example of the judge inappropriately minimising the risks of harm to A by saying that there is no evidence that F would be likely to perpetrate harm directly to A. And in my submission, language here matters. It is very well established, of course, that harm to a child caused by domestic abuse does not have to be physical, direct attacks on the child. It's well defined in PD12J. It's acknowledged in the case law, most significantly recently in the case of REHN. Exposure to domestic abuse and coercive control is obviously a form of harm to the child directly. And so the fact that it was put in these terms shows how the judge was falling into error and conflating the issues and minimising the harm to this mother and child. It's also, in my submission, just wrong to describe it as not a form of direct harm. If a child's mother might be murdered, obviously that is direct harm, and so is the evidence about the child being removed from mother and mother being prevented from caring for him properly. These are all direct forms of harm. Then the protective measures element is, with that background, further undermined, because it doesn't really appear from the judgment that anywhere there is a specific consideration of what risks A is actually going to be exposed to, and therefore how each measure will appropriately protect him. And in my submission, that is because in this passage taken as a whole, the issues have been conflated and the level of risk has been somehow minimised or lowered before the judge then comes on to look at the list of measures. It's also not specific enough in terms of what the child might be exposed to. I'm conscious of the time, and so in relation to B, before I come more specifically to protective measures, I just wanted to rely on really the overarching factual findings, even on the judge's analysis, because, as I say, this judgment meant that the family had paid the sum of €13,000, at least in part because of their fear of the threats that they were under and their desire to have some form of peace. If that's right, it's fairly incontrovertible and important evidence as to the level of risk from this father if this very young and vulnerable mother and child now have to go back and live in Romania, and be exposed directly to all of that and be within the father's sphere of influence, in his orbit, much more exposed and vulnerable to his control and influence and aggression. The fact that that isn't even mentioned in the analysis of the risk to the child under Article 13b is a significant and material error in my submission, and it again demonstrates how the situation here was improperly discounted, or the judge fell between two stools. In terms of protective measures, the judge comes on to put in place a list at paragraph 73. But in my submission, what the judge fails to do is engage with the question of how this package, or any particular part of it, actually protects A from the specific risks that exist. So, for example, 73 little 3, which is at page 109, refers to sum of money being paid before she goes back, and then also at little 4 that there will be ongoing payments of €500 and that the child benefit will be transferred. But those elements are only to take effect upon the child's return. And furthermore, the evidence of the Romanian SJE, which was obtained on the issue of protective measures, said that the financial aspects of the measures offered may not be enforceable because they're not measures going to the parental responsibility or the protection of the child under the 96 Hague Convention. And in the particular circumstances of this case, it is not adequate to return this child in circumstances where the mother will not even be properly and securely housed and maintained in the interim. It's it's obvious what might happen to this mother if she goes back and the father simply stopped paying, or if she's unable to properly care for A. It's not just about the physical day-to-day needs of A, although obviously no one would want him to be sent back to destitution, but it's also going to materially affect the mother's ability to stay away from the father, to protect herself from him and his threats, to be in a secure position with A pending further hearings, if she doesn't actually have the financial wherewithal to do that. And in this case, as I say, we certainly can't rely on the father simply to comply voluntarily. The little...
Well, just pausing there for a moment, and because in 66, the judge refers to the several family members that the mother has in Romania. And I take your point about the financial measures offered, but it would be reasonable, would it not? And the mother, of course, had stayed with her grandmother, for example, in the past. It would be reasonable
Yes.
for a judge to at least assume that the family would offer her and A a roof over their heads if
Yes.
if A was to return.
Yes, well, she might be forced to do that, but then if she were, the threats to kill are even more relevant because the father would know exactly where they are. That's the problem. And those are the options that this mother probably has. It's either rent somewhere and hope the money doesn't run out, but he still might find them anyway because he's determined, or just accept that she goes back to a family member's house, but they all live cheek by jowl in this area, and you've already heard about all the threats that have allegedly been made, so that's not really an answer. And yes, that brings me on really to the point about little 8 at paragraph 73, that the father won't attend at her residence without agreement, save for contact arrangements agreed or ordered by the court, because none of this is going to be enough if he actually decides to carry out his threats to kill. And little 9, not to be provided with the mother's address, well, obviously that might be irrelevant if she ends up going back to a family member's house, but anyway, it might be released by the Romanian court, and then all the same issues flow from that. The judgment doesn't really, as I say, engage anywhere with how this is adequate given the actual allegations that are made. Of course, they might be generally terms that would be included or commonly encountered in these cases, but every case has to be looked at on its own specific facts, and this one is so extreme. It is a case, in my submission, where this package is just not an answer to the evidence that's been filed.
Yes.
So in that way, the judge falls into error both by failing properly to analyse and explain the level of risk in the first place, and then also by failing to analyse how and why the protective measures would be enough. And a general reliance or reference to the legal framework in Romania in general terms, which is one of the points relied on by Moylan and friends as well in their skeleton argument, with particular reference to the case of G&D, Mr. Justice MacDonald, where it said that it should generally be assumed that the courts of the overseas state are as adept at protecting children unless the contrary is proved. Well, of course, that just says that it should generally be assumed, so in the ordinary case, but this is a case where there is evidence of extreme aggression and risks, and there is also evidence already that undermines any reliance on protective measures and other orders by this particular mother, because of the threats, because of the father's own actions that I've already described, and then there is some evidence as well that the Romanian police have not taken forward any complaints that have been made as seriously as the English police have. So, for example, at Supplemental 105, the mother said that no action was taken, and the father's own evidence is that he hasn't been approached by the Romanian police. And I've already addressed the father's actions in circumventing the mother's wishes and obtaining information about her. So all of that, of course, would be much more risky and dangerous and intolerable to this child if they had to now go back and live in Romania in the interim, rather than allowing A to stay safe and settled as he is and has been for over a year now, actually, with his maternal family in England.
Shall we stop? That clock, I think, is actually
Yes, I'm just looking at the time. I was going to just finally go through any points, but if that's an appropriate place to pause.
We'll give you 5 minutes at 2 o'clock, so we'll adjourn now and come back. Have you asked the question?
Yes. Maybe you could know the answer to this now, or maybe between you and Mr. Gupta you can find out the answer over the short adjournment. But what stage have the Romanian proceedings got to? I think there was a hearing in September. Not sure what's happened since. Perhaps at 2 o'clock you can let us know.
We'll be able to do that.
Thank you
Yes,
very much.
thank you. Court rise at able.